Alex Leonard, Aidan Briggs, His Honour Judge Paul Matthews, Professor Robin Jacoby. I don't think any of them need any introduction from me. Their reputation goes before them, and I think, Alex, you might be saying one or two things, perhaps. Also joined on a sort of informal panel by Leila Goodarzi and Rod Smith, who are partners in our Estates Tax and Trust team, just in case there are any easy questions on what I really like at the coalface in real life, rather than us litigators who think we know what should have happened with benefit of hindsight, which are quite different. So this opportunity at the end to catch up over a glass of wine is nice canapes if you can stay. But I think that's probably all I need to say, Alex. Over to you, or Fiona Bruce's. Thank
you very much, Michelle. And yes, apparently I'm supposed to fulfil the role of Fiona Bruce. I think that means this is question time rather than Antiques Roadshow. Let me decide at the end of the day. So we're joined, as Michelle says, by two partners in the non-contentious team from VWV, who'll be telling us what life is like at the coalface, Rod Smith and Leila Goodarzi, who are probably well known to all of you. The other speakers, closest me, first and probably least, to be fair, my good colleague and friend from New Square, is, I'm sure, known to you, has been in lots and lots of these cases, knows almost everything there is to know about the law of wills and trusts. One of the editors of Leonard Trusts, indeed, recommended by all the directories. I need say no more than that. Aidan Briggs. To his right, a face that will be familiar to all of you, probably strike fear into the hearts of all of you, His Honour Judge Paul Matthews, our local judge here in Bristol. And I'm probably thinking he may well be the judge who has decided more probate claims than any other practicing judges, maybe even going back to the days of the probate division and, you know, Herbert Jenner or someone like that. I haven't done the statistical analysis to confirm that, but I'm pretty sure it's true. He denies it. And to his right, Sir, not Sir, but Professor, it should be Sir, Professor Robin Jacoby, who is, when it comes to psychiatry experts, the OG and the GOAT. That stands for Briggs. Sadly for us all, now retired from taking on new instructions. So he wants me to tell you he's not here touting for new work. Do not attempt to instruct him. Politely turn you down. But we are nonetheless able to benefit from his great wisdom. Anyway, we have had some questions in from some of you, and we've also thought of some questions of our own around these three sort of areas: lifetime assessments, post-death assessments. And I'm not necessarily going to take them all in that order, but shall we kick off with a perennial bugbear? I know a certain bugbear of Robin's in a case called Hawes and Burgess. Now about 12 years ago, Lord Justice Mummery said that it's a strong thing to upset a will drafted by an experienced private client practitioner, such as the two we have sitting over there, on the basis of what an expert psychiatrist who's never met the testator says post-mortem. And this obviously upset a lot of psychiatrists, but pleased a lot of private client practitioners. Robin, did Lord Justice Mummery get that right?
Well, I think he didn't in that particular case, because I think that he referred, I think, in the judgment to the solicitor concerned 9 times as being experienced, because he did about 50 wills a year. My own view is that there's a difference between exposure and experience. But clearly, somebody who's seen the patient, seen the testator rather, is at an advantage. But on the other hand, you know, we're talking about 2 different things here, aren't we? We're talking about a will drafter, and we're talking about a doctor and an expert. And I don't see that that a solicitor, I think, ought to be susceptible to cues that are available at the time, but shouldn't necessarily be an expert him or herself. And I think that this particular solicitor was not aware of the particular cues. I mean, for instance, the appointment to make the will was not made by the testatrix herself. She had to be brought to the office. He didn't apparently find out about the medical history. So I think he was wrong. But, you know, in principle, it depends on the quality of the will drafter and the quality of the medical expert, but they're two different things.
And Aidan, in a case you and I had against each other shortly after Hawes and Burgess, that was qualified a bit, wasn't it?
Exactly, and I think really Robin's point is a good one. I would say it's actually the quality of the assessment that is undertaken, because there are those, and you know, very often they are very experienced solicitors who may have dealt with a client for a long time, who are entirely familiar with them, and who, for various reasons, may not either feel the need or even have any suspicion so as to inquire or test the capacity question. And so they don't necessarily ask the open questions that might reveal a lack of capacity. They may simply, you know, out of nothing more, turn up and say, well, yes, of course, you've read the draft that I've sent you, haven't you? Yes, good. And this is what you want to do. And this is what clause 1 says, so on and so forth. And they have a client who is quite happily nodding along and saying, yes, yes, of course, yes, yes, yes. And they get to the end and they make a careful attendance note and they go home again. Perhaps they may, and indeed, because they may not be alive to the medical history, the quality of the assessment that they've actually undertaken may be very different to one which you might, for example, take with a brand new client, where you've been forewarned about a potential issue as to their capacity. So I think it's as much about the quality of the assessment that the solicitor undertakes than who undertakes it. Because I do think assessment after the event is just a fundamentally different exercise to assessment at the time.
So going to our experienced private client practitioners, Leila and Rod, what would you do to make sure that your attendance note and your assessment falls on the right side of Robin's line?
Well, I acknowledge that one of the issues with knowing a client well is that you know, it's quite tempting to kind of think that, you know, someone's sort of changes might be foibles or, you know, eccentricities, where in fact someone who, if you say, is coming into the experience new might say, well, actually, there's clearly something going on here. So I think one of the things that you could do is bring someone else along with you. I think you have to check yourself and sort of dismiss anything which historically you have taken on board in terms of foibles or eccentricities, and to kind of step back and say to yourself, is there anything here which is ringing alarm bells? Or is there anything which is odd? And if there's something odd, to take a note of it, but also then to positively challenge the client about it, and explore it properly, and obviously make a careful note about it. So I think often reports will say, and they knew the client well, or they knew the family well, but really, in fact, that's almost like a danger point for someone who is regularly dealing with a client or a family. So my view is that if you can bring someone else along with you, and certainly don't fight shy of asking difficult questions, or searching around a particular subject, like, you know, how have you been? Have you had any issues relating to your health recently? You know, exploring that properly, rather than, as you say, sort of pressing on, getting a will drafted, and you've read the draft, haven't you, as you always do, and so you know you've got a potential problem later on down the line.
When you say bringing somebody along with you, do you mean you bring somebody along?
Yes.
Yes, yeah.
That's really interesting to hear you say that actually knowing a client before is its own danger area, because quite often I see it said, I've known this client for 15 years, I would know whether they were fine or not. But actually, that can be its own problem. So
I think so.
Leila, anything to add to what Rod said on that?
Not at this point.
To you, Judge, then, where do you fall in the great Burgess and ash kettle debate?
I think I fall over all the time, but let me just preface what I'm about to say with a general disclaimer. I may have to decide cases in the future, and I don't want people coming and saying, well, that's not what you said. We're not looking at the precise facts of any particular case. We haven't got the benefit of forensic argument from people of the quality of these two members of the bar, one saying black, the other saying white, which exposes in most cases where the better answer lies. So everything I say is at a high level of generality and not to be relied on as a statement of what the law is, for example. I think the point which has been made already, it seems to me to be the most important one, is that the nature of the exercise being carried out pre-making the will, the assessment at that stage, and the assessment by an expert who has never met the testator, the deceased. These are chalk and cheese. They are doing two quite different things. It's typically a case where the solicitor is not medically qualified, doesn't have any specialist knowledge. But remember that just being medically qualified isn't itself a guarantee of understanding the nuts and bolts.
Anything.
Psychiatry, which is a very special expertise within medical expertise, and therefore the solicitor has nothing really very much to say about the medical issues. That's just not what they can do. But the solicitor does have an important role in recording the things that were there to be seen. And I think that means that the attendance note is really important. And the experience of the solicitor helps to make the attendance note better and better. And I do regret the cases I sometimes have to deal with where the solicitor has not made a proper attendance note and cannot give the kind of information which somebody like Robin would find invaluable in making a medical assessment without having met the testator. Whereas what someone in the position of Robin is doing is looking at other data, other information which he has not himself observed or gathered, and trying to make medical sense of that. So in my view, I think that it all depends on what kind of quality of job is being done by the solicitor. Bringing a colleague who doesn't know the testator is very valuable. Not every case is justify the expense of doing that, but in cases where it can be afforded, then of course it brings an extra dimension to the question of someone that you don't, someone that you know very well, but the other person that you bring with them doesn't know and can ask the questions. Obviously, I mean, you grow up with the experience of doing this. I mean, through my career, I have sometimes been asked to go and assess someone's capacity to make a will before we actually get to the making of the will. And of course, all I can do is look at the sorts of objective phenomena that are there to be gathered and record them. I can't reach an assessment as an old age psychiatrist.
I'd say one thing about the attendance notes, which is the trap that someone fell into. I had a case where we had a wonderfully detailed attendance note from the solicitor who had taken instructions from the will and had gone through, which included kind of, long paragraphs saying, I was perfectly satisfied at capacity, they were lucid, and so on and so on and so forth. And when we got the solicitor's file, that obviously included the attendance note. It also, unfortunately, included the template attendance note that they used before they'd actually met the testator, which had all of that material already in it. So they basically just put in a name and a couple of details, which obviously we settled quite quickly. So it's quite
The better course, I always thought, to have a template, not of the attendance note, but of the questions or the points which you want to look out for. And then you could, if you like, you know, you go through and tick them off as you go and say, you know, stumbling, repeating questions, not remembering names, and so on and so forth. And at least then you've got something concrete to give the psychiatrist and say, well, that's what it was like.
Exactly right. Of course, the classic bad attendance note was in Key v. Key, where the solicitor wrote it on the back of an envelope.
The barrister, it was only found during the course of the trial, wasn't it?
Yes, I think so, yes.
Yes, I think it was our colleague John Ross Martin who was
Yes.
suddenly got a tug on the back of his gown. I found this, is it relevant? Which doesn't necessarily accord with the witness statement you've written. Oh dear. That was good. So that's how to make a good attendance note. How do we make a good expert report, or at least make sure that our expert can do the best they can for us? Because we've got this, Hawes and Burgess, as I said, was 12 years ago. We had Leonard and Leonard much more recently, another case where expert evidence has been sort of not applied by the judge in favour of the judge's own view about how the testator's capacity stood. How can we make sure that experts' views are given due weight? Can I start with you, Paul? What do you like to look for in a good expert report?
Well, there are some obvious things that you look for. You want someone who doesn't go outside their expertise. People who start telling you things that are obviously not part of their expertise, that casts considerable doubt on what they say that is within their expertise, because they're obviously not careful enough. Secondly, because you're an expert who, in most cases, has not seen the deceased in life, you are necessarily working from other people's information, and it's necessary that the basis for your opinion, the factual basis, is clear, and that you are clear what it is as an expert that you are basing your opinion on. So that might be, in some cases, you might have had the advantage of a physical examination for some other reason during life. But in most cases, it'll just be the medical records and the witness statements, and you mustn't go beyond them. That's perfectly obvious. There are also experts who lose points, so to speak, or lose weight by massaging their opinion. That might be because they feel pressure put on them by the clients or whatever. But again, judges spot that. They're not stupid. They can see that you are acting, however slightly, as an advocate, and that goes down very badly indeed. And then there's a point about inferences. It's really not a good idea, if possible, to try and draw inferences. Let the judge do the inference drawing. Give the judge the materials which enable the inferences to be drawn, and then let the judge do it. So a report that starts drawing inferences all over the place, to my mind, is suspect. Partly because it's usurping the function of the court, but also because it's just that person's view about what inferences ought to be drawn.
And Robin, have you seen rival experts fall into some of the traps that Paul's mentioned, or?
Well, I agree with every word Paul has said. I absolutely, and I have, I have seen no names, no pack drill, but I have seen experts who essentially are batting for the client, and I think it's terribly important for experts to realise. They state it at the end of their report. They have to state it, that they are batting for the court, not for the people who instruct them. And I think I always quote, I don't know whether it's appropriate to say that, Ashkettle, where I was an expert, where, I was instructed by Aidan's side, as it were, but I thought I was more helpful, in fact, in the end, to
He still hasn't forgiven you for that.
I couldn't possibly comment.
But simply because I think it's so important that if you're seen to be partisan, you lose credibility. I think you lose credibility with judges for that. I think that's
No, I would certainly agree, and I think there is a helpful distinction that was drawn in Leonard and Leonard in terms of the material that the expert is asked to give an opinion of. I mean, in that case, it turned out that the two experts had been provided completely different material to start with, and so therefore, when they first met, they said, "Well, we can't agree on anything because we've both considered different material in reaching our conclusions." But in Leonard and Leonard, actually, it was considered much to have their views on, as it were, the agreed contemporaneous documents, the medical records, and these, which at least are sort of beyond dispute, and to say what can I conclude by reading those, and what can I tell the court about what these medical conditions might have in terms of an effect on capacity, so on and so forth. What solid conclusions can you draw from the incontrovertible medical evidence that is available, as opposed to, and I think this is really the point that Paul was also alluding to, if you start saying, well, if they sent an email like that, then if the witness is, if this piece of witness testimony, which we all know is hotly contested, is right, then ... I'm afraid I take the view there's very little benefit in asking the experts to review all of the witness evidence and give a sort of addendum opinion or a further opinion. And likewise being cross-examined, well, you heard from so-and-so earlier today, if what they say is true, then wouldn't you agree that? I think at that point, the frame of reference is lost. And I just think it becomes unhelpful to the court, because they've essentially got someone saying, well, if those were the facts, then maybe this, if these were, I can't really say much. I think it's much more helpful to both sides to say, well, based on this limited information, this is what it tells me. Apart from that, it's really for the judge to draw their conclusions from the evidence.
So you think if you give an expert witness statements, especially if you only give an expert witness statements from your side, then you're handing the opposing side's counsel lots of cross-examination material.
I think so. I think inevitably, you are, when it comes to cross-examining the expert, you're always looking at what have they based their opinion on? What can you undermine from the view that they've reached? And I think going back to, you will have some experts who will stick to the view they've taken, even on any number of other assumed facts, or even kind of no matter how much you take away from the basis, which rather suggests to the court that they have just decided what their view is rather than what the right inference from the facts is. I think it's much more compelling if they say, look, I've just looked at these documents which everyone agrees on, and I can go from there.
Do you prefer, Robin, to see some witness statements as well as medical records, or would you like to be left clean and
well,
untouched?
I mean, it's sort of it's what I've been sent, and I get sent witness statements from both sides, or have been, and the way I deal with them is something like the statements of a section, the statement of lay witnesses. And then I always have a little paragraph just below that saying, I recognize statements of lay witnesses are the sole prerogative of the court. The facts are the sole prerogative of the court. I don't decide, and I'm not in a position to decide which are true and which are not. But I will then, for example, if there's a lay witness who gives a very clear description of some form of cognitive impairment, I will say, well, if the court finds this to be true, that would support a diagnosis of dementia, shall we say, and leave it at that.
Might you say, this witness's evidence is consistent with the medical records or the picture that emerges from the medical record.
Yeah.
This witness's evidence seems a bit unlikely given what the medical records say.
Yeah, well, yes, I might say that, but on the whole, I think, then you're starting to tread on the toes of the court, which is so, so important not to do. I just will take bits from the witness statements, and this would support the diagnosis of mental illness. I mean, I wouldn't touch facts. I don't think I would touch facts that have nothing to do with the issue of mental disorder, because, as the point has been made, the expert has got to stick to his last. The cobbler has to stick to his last.
Does that sound right to you, Judge?
Yeah, one of the most important features of a really good expert is that the expert allows that there is room for more than one view, polyvalent, that there is a range of possible answers to a question, and that because the experts have not seen the deceased in life, the answers of two perfectly competent, reasonable experts may be different. And that is something that I find very, very useful. That it's often been the case, and certainly in cases where Robin has been one of the witnesses, and the other witnesses have been equally good. You will get that. You will get them saying, look, it's falling. I say it's this side of the line. Him over there says it's the other side of the line. That's perfectly possible, but it depends on the court's appreciation of the facts found.
Yeah, well, that's exactly right.
And that is very attractive to a judge, to find someone who's prepared to be intellectually honest about what's going on.
Well, that's exactly right. In the case, one of the cases you referred to, I remember Penny Reid cross-examining me and saying, well, it's a very fine distinction, isn't it? And I said, yes, it is a very fine distinction.
Yeah.
Am I allowed to ask you questions, Michelle?
I might defer to my front bench, but
Obviously, when we're advising clients, we often get an expert report before proceedings are underway. And therefore, when our witness statements might still be in draft. And so we're feeding our expert at that stage, if we're going to give them anything at all, information which at that stage is privileged. And so we run the risk, I guess, if you give an expert a draft witness statement, that the other side at some point will see, well, can I see your draft witness statement? And then they've got some lovely cross-examination material comparing the final witness statement that they've been served with the one that the expert saw at an earlier date. Do you have a sort of strategy for managing that risk?
we do. And when it had come up, what we might do is not go to our expert of choice to get a steer, and then conflict that person out of the other side instructing them, and then yeah, so it's complicated, Alex.
Chess, Michelle, but isn't the danger the other side then tries to instruct them conflicting? Then you get accused of expert shopping.
I think we probably don't tend to disclose draft witness statements for that reason, because we're very cautious. I mean, we know that everything will be disclosed, but eventually.
There was a case, I think, where Robin was on the other side from me, which never quite went to trial, where we had quite a lot of fun and games with getting disclosure of some draft witness statements that you had seen at an earlier date, and comparing them to the final ones. But yeah.
I do remember on one occasion, it wasn't my case, but it was in the firm next door, where they actually went and saw the expert conference, gave orally to the expert the substance of what the evidence would be, so that there were no documents. But no, that's not something you can do in every case.
Yes. Can we go back? Oh, I've got a hand up from Amanda.
Trouble is that GP reports, the GP, generally GP evidence that you're looking at, and with 10-minute consultations, And GPs don't often put down that they think that a person is suffering from dementia unless it's actually raised by the family. And that this is a really a problem. Also, the patient, as it is to the GP, doesn't want to be diagnosed as dementia because they're old and proud. And then you've got a real problem, because if that's all that the expert, the old age psychiatrist is looking at, he hasn't got much to go on.
Oh, you mean the medical records
Medical
may
records aren't
not
enough.
actually
Yeah.
betray the GP's
Real
assessment.
Real assessment.
And that, I guess, might be true even if it's a sort of golden rule assessment.
Yeah.
That Leila or Rod has asked for.
I mean, I think the best thing is to always ask the GP if you've got to get following the golden rule. If the client goes to a specific GP and isn't sent to a different GP every time they turn up at the surgery, it's best to go to the trusted GP who actually knows the person pretty well. But if you don't have that and you're just relying, and the ex post facto old age psychiatrist such as Robin is looking at it for the first time because there's no golden rule assessment at the time, then the GP's reports were often not good enough, to be honest. And so, you know, the expert then just has, if he's not looking at any witness statements as well, has got very little to go on.
So, Leila, when you're getting a golden rule assessment, do you go to the client's GP or do you go to someone else?
Well, I'm just looking over at some of my team over there. We have increasingly been using independent private social workers. We find the GP route challenging, and not all that forthcoming. And yeah, they're not that up for it, even if they get paid for it. So we've been starting to use increasingly independent private social workers, basically.
Robin, I know you've got thoughts on this topic of GPs and capacity assessments.
Yes. Well, I've had some very strange ones. GPs don't know their patients really, so it's a problem. I think the problem with instructing social workers is that they're trained to assess capacity under the Mental Health Act and not under, not for contentious probate. But that's, I suppose, better than nothing. I wrote an article in the British Medical Journal decades ago with Peter Steer on sort of saying how GPs could do capacity assessments for women. I'm not sure whether I'm in agreement with it now, because I think what has to happen if a GP is going to is asked to make an assessment, first of all, the solicitor has to inform them of the Banks v. Goodfellow criteria. Otherwise, you might get one under the Mental Health Act, which is better than nothing. One GP, when asked to do an assessment, produced an off-work certificate, and that was all. So I think the GP has to be given all the information on previous wills, medical information, family history, all that sort of thing. And if you're using a private, if you're using private people, then I would have thought it's better to, if old age psychiatrists are not too expensive, to use them. They are properly trained to do those sorts of commercial.
It's hard to find.
Yes. Yeah. Although you've got very good old age psychiatry.
I do think there's let me start again. When I see that some of the evidence in a probate case consists of a GP's report, I nearly always find there's not enough information about the GP and the GP's experience, which would enable me to put much weight on it.
Yeah.
I mean, the problem with a GP in this context is the word general in the title. Yeah, that's the point. You're a general practitioner. You're not an expert, although it's fair to say that some GPs do courses and get diplomas and so on in in psychiatry. The fact is that unless you're told that the GP has got some specialist knowledge, you start from the assumption that it's a generalist, and therefore you wonder just how much weight you can put on it. I did a case a year or so back, Oliver and Oliver, which I think some of you may have heard of, where the GP of the testator actually was one of the witnesses. And I found that his assessment on the facts of that case, his assessment that the testator had capacity was wrong. That in my view, he didn't have that capacity. I also found, for what it was worth, that if he had had capacity, there was undue influence. But that's another story. So I would say, if you're going to use GPs, make sure you've got some kind of extra experience for your GPs. B, make sure that this is properly brought out in the GP's report so that the judge can see that there's some weight to be put on it.
It seems to me there's a difficulty in the laws emerging, because on the one hand, you've got Hughes and Pritchard and the Court of Appeal saying it doesn't matter what decision the testator is going to make, what will the testator is going to make, the GP can nonetheless say, have they got capacity to make it? On the other hand, you've got cases where, like Leonard, where the judge says it's the specific will that's being made that sets the bar for capacity to make it. And so in the case of mine, we've got an assessment where the testatrix said, I'm not actually going to change my will. And so the assessor said, well, she's fine not to change her will. She's got testamentary capacity. And then she did change her will. And so the validity of that assessment seemed to be very doubtful in the circumstances. But yeah, how do you deal with that, practically speaking, if you don't know for certain when you're sending the person off to get assessed what decision they're going to make in relation to their will?
Well, the capacity's got to be decision specific, and that has to be affected by the complexity of the arrangements that you're putting in place. If your will is, I leave everything to my wife, and if she predeceases me, I leave everything to my 2 children. That is a much simpler document than I have the following 6 discretionary trusts with categories of beneficiaries and so on, and loans and so on. Wills come in many different shapes and sizes. And I do, although we have a single test of testamentary capacity, but I do think it is decision specific. It will result in a different threshold for different kinds of decision and different complexities of estate. So often you find that the GP in these cases hasn't asked anything about what are you actually disposing of? What is it you're giving away? Because some people's estates are very simple, some people's are finely complicated.
Of course, the great case that shows that it's really decision specific is Park and Park, which is a very old case now, where in two cases of litigation, the same testator was found to have capacity to marry his second wife on a certain day, but not to have capacity to make his will 4 hours later.
Yes, which obviously is one of those issues that talks about brings up the question of predatory marriage.
Yeah.
And we know that was one of the things that the Law Commission reconsulted on the year before last in its sort of supplementary consultation paper. And we also know that we're going to find out, I think, next Friday, what the recommendations of the Law Commission are going to be on this topic. So very much a watch this space issue, which is also causing me difficulty with editing the new edition of Theobald and Wills.
Alex already knows, he's just not allowed to tell us.
So it's like drawing on that point when we're trying to work out whether a testator has a problem or not, and if they do have a problem, is it a permanent problem or a temporary problem that could resolve itself? One of the questions we sometimes encounter is, when is someone suffering from just a urinary tract infection or some temporary thing that's causing them to be a bit confused? Because you look through medical records and you see on this date and that date and that date, they say confused or disorientated or
Pleasantly confused.
Pleasantly. And on other, well, on other dates, it's not mentioned at all, but that can leave an expert, I guess, with a difficult decision about what's long-term confusion and what's short-term confusion. Robin, how do you go about sorting the wheat from the chaff?
Well, what we're talking about is the difference between dementia and delirium. And dementia is essentially a global impairment of higher cerebral function in clear consciousness, whereas delirium is a global impairment of higher brain cognitive function. Without, but with the hallmark of it is impairment of consciousness, conscious awareness. And people with dementia are particularly vulnerable. But not only those with dementia, but they're particularly vulnerable to intercurrent infections such as urinary tract infections. Somebody who has, as a general rule, I mean, and rules can be broken, but as a general rule, somebody with delirium, I think, would lack testamentary capacity. Whereas somebody with dementia may not necessarily lack testamentary capacity. I think if somebody has been assessed, somebody with a history of confusion, you have to find, I mean, there's no more confusing word in medicine than confusion. That's what we're taught. What you have to mean is an impairment of conscious awareness, an impairment of oneself and one's surroundings. And if that's the case, that particular person at that time, of course it's task and time specific, I would almost certainly lack capacity.
So for we as lawyers, at an early stage in proceedings, we probably get the medical proceeding,
Yes.
medical records in.
Yes.
We look through them and our client says, is it worth spending X £1,000 on Dr. Series or Professor Howard? And we can spot a confusion here or there. Are there any tips you can give us to try and tell the difference when we're looking through records?
Well, it's sometimes very difficult because the quality of medical notes is pretty poor these days. You know, you get sort of pleasantly confused. It's almost certainly, or it's highly likely, put it like that, to be a delirium. And you have to look for occasions when somebody's made a note about the patient when they don't appear to be confused in that sense, delirious.
Because I wouldn't know how to interpret a urine test result, for example, that you
Yeah.
might see in a medical record. Are there key words to look out for?
Well, I mean, you'd look for evidence of an infection.
Yeah.
You don't have to for evidence of an infection. You know, they might say riddled with whatever it is, staphylococcal or streptococcal bacteria.
You could also look and see what the doctor's treated it with.
Yes, yes.
If you're giving antibiotics
Quite.
as a reason.
Yeah. But of course, not all people with a urinary tract infection become delirious. Confused. So it's complicated. And I agree with you, having waded through so many medical notes, that it's sometimes just totally impossible to tell.
And another difficult issue I think that we're asked to advise on is when do medications or combinations of medications raise question marks about capacity? And you see people in palliative care who are maybe on oral morphine.
Yes.
Probably half a dozen antibiotics as well, some antiemetics and all the other things. And quite often I found, well, surely this cocktail of drugs is enough to make you think there's got to be a problem. And you send it off to you or one of your colleagues and they say, no, it's probably fine. And Oh, really? Okay, that's disappointing.
I would say with that, in the cocktail, with that sort of cocktail, they are vulnerable to delirium. And then you would have to look for evidence that they were delirious. Old people are particularly vulnerable to the effects of prescribed drugs.
Have you seen any cases like that, Aidan?
I mean, I've certainly had endless cases where the person challenging capacity, the party challenging capacity has said, well, they were on these drugs. And if you go through the NHS website in relation to that particular drug, one of the many side effects listed will almost certainly be, confusion, dizziness, such and such. But that doesn't mean that it actually manifests in every case.
Right.
It doesn't mean that that is going to be a result. It is one of many possible outcomes, and in some cases they miss out the section where it says 1 in 10,000 people will side effect. Yeah, I think it unless you're on something really extraordinary, doesn't tend to be a very fruitful line of inquiry.
Yeah, the real danger area for will drafters is deathbed wills. Very, very dangerous area.
So yes, when is the deathbed will valid and when is it? Well, big question.
Yes, the trouble is that often, in my experience, will drafters come in and ask nurses to say, does this person have capacity? And that, I think now it's universal for the hospital policy to say nurses must not
Yes,
no,
they mustn't witness wills.
wills.
Yeah.
Exactly.
All the nurse cares about is whether they've got capacity to consent to a bed bath,
Yes.
not whether they've got capacity to
Yeah.
make financial decisions.
Then you see also, well, shall we call a junior doctor? And I don't think a junior doctor is necessarily, somebody straight out of medical school is necessarily able to assess capacity. So you have to go on what the medical notes say at the time. I mean, ideally, you need to get a consultant in who, a consultant geriatrician or a consultant old age psychiatrist to see whether this person has capacity to make the will.
And Paul, you were making a point to me earlier about the policy of the law in this area, wills for the elderly and those who are terminally ill. And that sort of comes into conflict with.
It does a bit. I mean, the standard that is required in terms of capacity to make a will is deliberately quite low. And it's deliberately quite low because making a will is something that old people do. And if you make it too high a standard, you'll stop most people from being able to make a will. So you can't make it too low, obviously. But you can say, look, it doesn't have to be a sensible will. It can be capricious, it can be nasty, provided this person actually had not the actual understanding of every asset which he or she owned and remembered the names of all of his grandchildren, etc., but had the capacity to know those things. Whether that person actually did have it isn't the point. So you can see it's actually quite a low standard. And we must be careful, there is a danger of this, of driving it up all the time so that it becomes increasingly difficult for anyone to make a will at all, who has got any kind of impairment. When we all know that there are people who might think they're Napoleon, but as long as it doesn't affect who they think they want to give their money to, it doesn't matter.
This is a real bugbear of mine, particularly in the cases that I deal with that tend to involve those with very complex estates, who are, the beneficiaries of certain trusts, who maybe the donors have powers of appointment, who, there are a number of factors at play. And this happens in lifetime assessments and also in post-death assessments that, it will always be open to one party or other to say, well, this was such a complex decision. They couldn't have appreciated the knock-on effects of choosing this course rather than that course. They didn't appreciate the tax implications of what they decided to do. They didn't understand, that doing this would prevent so-and-so from also being able to do that. you get to these, particularly when you're trying to settle on a lifetime assessment, you're trying to instruct the expert. And there will be one side saying, no, they have to understand this and this and this and this and this. And the list goes on. And invariably, my experience is that when we get before, if you can ever get before a court of protection judge, which is very hard to do these days, you get before a court of protection judge, invariably, in my experience, they say, no, I sweep all of this aside. The decision is this. It's a very simple decision that you need to make. Do you want to give these assets to those people? Then, all of the tax and everything else, I won't say you can completely ignore, but that is a follow-on consequence. The core decision is this one. And I think the other thing that people forget is that both Banks and Goodfellow and the Mental Capacity Act provide that you should be given all available assistance to make a decision. And if if what you have to, and it's certainly one of the cases, the one that I'm thinking of, we put together as a decision tree in visual form to help this person make the decision they needed to make. There was a lot of back and forth argument over what should be in the decision tree, and one side was saying it should be kind of this sort of A0 gigantic thing with 16 branches, and we did eventually settle on a piece of A3 that could that was pretty easy to navigate. But it is a misconception to think that they have to understand everything that the lawyers can invent about the decision in order to make it. That is just not correct.
The lowest standard of capacity, one even lower than making a will, of course, is marriage.
Yeah.
That was the Park and Park case.
Yes.
You don't need to understand that it revokes your will. Not a necessary component of the decision.
Well, that's good for predators.
So, moving away from that, let's assume that we've gone to a solicitor has applied the golden rule, a will drafter has applied the golden rule. We've got a report from whether it's a social worker or another psychiatrist or a GP, whoever it might be during life. They've assessed this person, and then they've died, and then there's litigation. You might not want to necessarily instruct as your expert that person who saw testator or testatrix in life, but you still will want, or one party or another, I guess, will want to call the person who's seen them in life. How do you treat that evidence of the person who's seen them in life? Are they an expert, or are they a witness of fact, or are they somewhere in between? And how do we deal with that under the civil procedure rules? Can I go first to Aidan on that question, because I know it was something we were debating on our Chambers WhatsApp recently.
Not an important debate that goes on in the Chambers WhatsApp group. I'm very clear about this. I think it is evidence of fact. It may be one of the facts that it is evidence of is what someone's opinion was at a given point in time. But in my view, it is no different from finding, a doctor's note in the medical record that says clearly did not have capacity. That is the view that somebody reached at a given point of time, and that is evidence of fact that the court can take into account. And it may well want to interrogate and say, well, what, as Paul mentioned earlier, what did they know? Or what information did they have in front of them when they reached that conclusion? But I still think it's evidence of fact. And I think you would cross-examine the individual as to how they reached that conclusion and on what basis they reached that conclusion. But I still think it is fact rather than opinion.
Michelle, would you agree with that?
Absolutely.
Wise. Leila, do you have a thought? Or Rod, do you have a thought on that before we?
Rightly or wrongly, I've always thought that it's a good idea to revisit that report with the individual if you can find them and they're still willing to kind of yeah, well, I guess so, to revisit their report and to possibly provide a kind of update based on any other things which have happened in the meantime. And that to me seems to be quite powerful if it remains the same, obviously, because they have met them. And
I do. Oh, sorry.
Obviously, depending on the quality of the report, but assuming that it's a good quality report, then they are speaking from experience, and they'll have their own report to kind of trigger all those memories, hopefully.
I think there is a real danger, and this came up in Ashkettle as well, with the person who made an assessment then being asked to give a view, or at least, you know, in the course of their evidence, stating a view as to what someone's capacity may have been at another time, or even, I think even, however, unconsciously or consciously taking into account other facts of which they have subsequently become aware in giving a view on capacity. I think if they're saying this is what I thought then, and this is the information it's based on, I think that's fine. I think if you then try and use them as an evidence of opinion, as an expert, then you are mixing up two things.
Or at least the person who saw them in life might not have the great experience of Robin or one of his colleagues in writing the report and applying the right test and so on. I mean, just to play devil's advocate, it seems to me, even if it isn't what the person's opinion was at a particular point in time, it's still opinion evidence, isn't it? It's not just I asked this and he said this. It's still saying, well, at the time I assessed them, they had capacity to make a will, in my view. Paul, where do you think you would come down on this point?
I think you're right. I think that the lifetime assessment document, or rather the person who made that document, is potentially giving evidence both of fact, what I observed when I assessed the patient, and evidence of opinion based on my assessment and the facts I observed when I assessed that person. In my opinion, that person had or had not capacity. And I think a potentially clearer example of what I mean is in a different context is if you have a forensic pathologist who carries out a postmortem examination, the evidence that the forensic pathologist gives, say at an inquest or in a court case, will be of two different kinds. It will be one, this is what I found on examination. Two, this is the cause of death. Now, the first is clearly factual, and the second is clearly opinion. And I think the same is just as true with the pre-death assessment. Now, you say, and you began with the point, well, doesn't that mean you've got a bit of a problem in the fact that you don't want this pre-assessment person to be called as
your expert?
Yeah. And I think that's fine, because I think there is no doubt, and there's Court of Appeal authority for this, that you do not get expert evidence into court only by means of Part 35. Indeed, Rule 35(2), and this is what I've just checked to make sure that the old memory box was working. Rule 35(2) says this: a reference to an expert in this part is a reference to a person who has been instructed to give or prepare expert evidence for the purpose of proceedings. But the point about the pre-assessment is that that's not what you were doing. You were not doing it for the purposes of any proceedings. Therefore, it's not an expert, and it's not an expert for the purposes of Part 35, and therefore you don't have to follow the Part 35 rules in order for that to be admissible. Still needs to be the right quality of expert. It needs to be somebody who's got a bit of experience, and
someone who can give
it. Exactly, but it's not caught by Part 35. And Rogers and Hoyle, which is the Court of Appeal case I was thinking of, it's not about this sort of thing at all. It's about the view of an expert as to the cause of an air crash, but it doesn't matter. In that case, the Court of Appeal made it perfectly clear that a person who was not being instructed for the purposes of the proceedings, and in that case it was the official inquiry into air crashes, which is set up by the Ministry of Defence or someone like that, that evidence was not subject to Part 35 and could be given outside the confines of Part 35. So I think the answer is yes, it's perfectly good expert evidence in principle, provided it's the right person and so on. And it can be given, and you don't have to give it. It isn't under Part 35, and therefore you don't have to instruct that person, but it's open to the other side if they think it's worth their while to call that person at trial. That's my view at the
That's
moment.
very reassuring, because the case, it came up in one of mine, was where my solicitors, I think, wanted to call the person who'd done the lifetime assessment, but had missed the date for witness statement of fact. And I said, well, just get it in quickly and put it in an application.
Yeah.
Just to play it safe. And by the way, we're still calling our actual expert.
Yeah.
As an expert, yeah. Does anyone have any thoughts about that? Has anyone come across that as a point?
And something similar comes up when there have been court of protection proceedings during lifetime. And you
Yes,
then
you want the file.
You then, I mean, obviously you've got to get permission from the court of protection to adduce the documents. But once you do that, it's a question of, well, it's evidence of fact.
And could you go further than that? Because obviously Larke and Nugus is the principle that the executor should, if the solicitor disclose the will file, and if not the solicitor, ask the solicitor for the will file and disclose it. And that's for the benefit of the court in making sure you've got all the information the court needs to make the right decision, or at least for the parties to avoid court at all. But could you go further and say, I want the deceased's other files, I want their property transaction files, I want their LPA making file. Maybe if there have been court of protection proceedings, I want the deceased's court of protection file. And this is a point that I had argued about in front of Master K last week, a week before last. Well, I'll tell you what happened maybe after all. After the other
Had a few glasses of wine.
after the other analysts have commented, but do you think how far can you push that Larke and Nugus principle that privilege in a file should be waived to help the court or the parties grapple with a probate claim? Michelle, do you have a thought on that?
No.
It's a difficult one, I think.
So I was in
Who wants to go first?
I was in a case called Tabit, in which Master Clark, Julia Clark, held that the Larke and Nugus principle doesn't just apply to solicitors. It applies more broadly to individuals who were involved in the preparation of the will, and it is very much policy driven. The Larke and Nugus jurisdiction, if you can call it that, it's an unusual beast, Larke and Nugus in many respects, but I don't see why it should only be limited to the will file, because as Alex says, I think the underlying principle is there are documents which the executors have in their possession or control because they inherit the deceased's privilege, which can assist the parties in determining the question of the validity of the will. So I don't see any principal reason why it should be limited to the will file if there are, as Alex says, other documents that are obviously relevant. I can foresee there being an issue if their court of protection document. Be an interesting question. Do you need the permission of the court of protection to produce those documents prepared for the purpose of court of protection proceedings? I think you do. I think you need the permission of the court of protection to reduce those in other proceedings, but that's, can be done.
Robin, how useful would you find it to see other solicitors' files relating to things other than the will when it's less incapacity?
I think the more you see, the better. Yeah, one is permitted. Especially court of protection proceedings.
Yes, so the case that I've got on at the moment is, and the one that was arguing last week, is where there's the court protection file, the court protection documents have been permitted to be used. The P who made the lasting power of attorney, which was in dispute, was a party to those proceedings and had her own solicitor, and made and was the same solicitor as made the will. And I was trying to get sight. I'd been the opposing party in the court of protection, and now post death, I was trying to get sight of others. These own solicitor's file, which is a contentious litigation file. So it's quite a bold application in a way. I didn't get pushback per se on the principle that files other than the will file could be disclosed. But I think in view of the Master's anxiety about showing an opposing party someone's litigation file, it was sort of, I won't say fudged because that's not quite fair, but said, wait until you've had full disclosure in the case anyway, and then come back if you really think you still need these slightly more difficult, contentious files. Dare we ask the judge what we've done in a scenario? You don't have to answer if you don't.
I think I preface what I'm going to say in this way. Before I came into this room, this would have been what I would have thought. Okay. There's obviously room for more than one point of view. But my initial reaction, and I saw the list of questions which was circulated containing something along these lines. First of all, I've always been very worried about the exact extent of the Larke and Nugus jurisdiction. It seems to me to be extraordinarily nebulous. No one appears to have considered problems of privilege. And therefore, one day there will be a case where it says, well, what about the privilege attaching to the file? Yeah, and who gets to exercise it? And if it's, say, the executor under the will or the administrator, which of course is an open question because you don't know whether the will is valid, but whoever it is, and I suppose that person says no under no circumstances. Can you force that person to, as it were, give up the privilege? And it may be that the Court of Appeal in that case, if they had thought about it, would have gone to the logical conclusion and said yes. But in fact, I think the decision was only about who paid the costs, wasn't it?
Oh, yes.
It was only,
This is very limited.
it's a very limited case. It's not about privilege. It's not about somebody waiving privilege. It's about who pays costs. And, you know, that really worries me that people are building too much on the result in that case. My instinctive reaction is no, you cannot require anyone to waive privilege. There are almost no circumstances short of statutory authority for requiring anyone to waive privilege. And, you know, there are House of Lords cases saying, or old cases in the House of Lords saying, even if the information is required to save somebody from being convicted wrongly of murder, you still can't require someone to give up their legal privilege. And I would fight tooth and nail. Before I came into this room, I would have tooth and nail for that as my point of departure. Privilege is sacred, and you cannot require people. So even if
Larke mentioned that Paul writes a book on.
Yeah, it is on disclosure. That's true. Yes. Even if Larke and Nugus does go to the extent, which I'm not sure it does, of requiring privilege to be disclosed in the will file, given up in the will file, I would resist in principle the notion that it should extend any further than that. That's my position
With my judge. I mean, the way we put it was you've got the executors as the necessary parties to the probate. You've got them before the court.
Yeah.
The court has a jurisdiction to supervise the administration of estates and trusts.
Yeah.
And where you've got executors who are between them at loggerheads, or we don't know exactly who the executors are, the court can make a decision as to whether it is in the interest of the estate to waive privilege or not. And in these circumstances, the court can say, yes, it's in the interest of the estate to waive privilege because then everyone's got more information. We can negotiate more successfully. We can get to the right decision in the probate claim. So that was the way I was putting it, not to say a party has to waive privilege per se, but that the court can tell executors whether it's in the best interests of the estate.
But surely, even if it is in the best interests of the estate, and you can say to the executors, you know, ego te absolvo, you know, you are not guilty by waiving privilege. That doesn't require the person to do it.
We had, Law Society republished their guidance on this, I think it's probably 2 years ago now, and I was involved in the working group that was, you know, batting this around. And we all agreed with exactly the point that Paul has made, which is that the underlying basis of this whole thing is very unclear. You know, it's done as a matter of convenience and general guidance. But, you know, there was the vexed question of, you know, can you charge for, you know, the costs of preparing a Larke and Nugus file, which rather raises the question, well, hang on, who are you acting for? Who are you, you know, what, and yes, nebulous is a good word to describe it. It's used all the time and often proves very helpful. But where does it actually come from? What's the root of it is far less.
Any contributions from the floor on this rather vexed topic?
If I expressly tell my solicitor the reasons why I'm not giving my sister Jane anything is for X, Y, and Z, and on no account is this information to get out.
It's a valid point. Just as I'm really interested to know, by show of hands, who here charges not just copying costs, but who actually charges for answering Larke and Nugus requests? You know, there's definitely a spread across the profession as to who does and who doesn't.
I think the Law Society now says you can.
Oh yes, certainly the Law Society says you can. There's very little consistency between firms as to what they choose to do.
Alex, on the issue of privilege, I wonder if it's linked to what are the pleaded issues that are there, because there is an analogy. I think one of the few exceptions for waiving privilege is where you've got a solicitor and client situation where it's not so much the waiver is forced, it's that the client can't assert privilege if they're in dispute with their solicitor in respect of certain things. I'm relieved to see the judges nodding.
Well, that's certainly one of the exceptions.
Yes.
It's not necessarily clear to me at the moment how that could help in this context.
Yes, I think it's good. The question is what is the actual issue in dispute that means that will make us file is relevant to the determination of the pleaded issue, and one of the parties would be disadvantaged by the other party being able to say that's privilege, you can't go near it.
Well, the privilege belongs to someone, and the first step must always be to say, to whom does it belong? Typically, it belongs to the estate of the deceased. And then the question is, well, who represents the estate of the deceased? And you may have a difficulty there.
Well, hopefully one of us will have the first reported case on this. What exactly is Larke and Nugus all about?
Bring your cases to Bristol.
It's the right time. Let's move on and talk about, I mean, obviously the sort of core thing that the psychiatrist will opine on in the expert report is capacity. But as anyone who's seen one of Robin's reports will know, he will often list presence or absence of particular red flags which might make a testator vulnerable to undue influence or the like, even if they don't make the testator incapable. Do you think it's, I mean, would you have liked to have opined more on undue influence in your practice?
Well, I have to be very, very careful because, you know.
Not anymore.
Well, no, when I was writing these reports, because I could easily be accused of the cobbler not sticking to his last. However, what I say is that if it's of assistance to the court, I have published a paper with a number of international old age psychiatrists, sorry, on the subject, and we did research the subject. And in different jurisdictions where coercion is not necessarily the criterion or required, I make a disclaimer that if the court wishes to have this assistance, then it can read it. Otherwise, it can ignore it.
That's very clever.
Well, yeah, but I mean, it's yes.
Yeah. So Michelle, when you instruct experts, do you say
That no difficult question.
But do you like to ask your experts to weigh in on the question of, if not, was there undue influence, but is there vulnerability?
T.
And from the non-contentious point of view, do you keep your eye out for the same sorts of red flags that Robin's looking out for? And how do you go about recording that and keeping yourself safe as well as your clients?
Yeah, and that's often a not just one, it's not just one red flag, because that could just be fine in and of itself. It's just it's the culmination of many things, as talked about somebody else booking the meeting, and then, you know, please send all emails to my, there's some of them obvious, some of them aren't, but it's when they're together, you start to think, okay, yeah, we just have to manage that. That it, you know, we can either go forward or we can't.
Aidan, have you found it helpful when negotiating cases to say, look, our expert says that your data was very vulnerable?
Yes, I think vulnerability to undue influence is you know, a legitimate point on which the expert can give a view. There are those who are tempted to trespass into their own views as to whether someone was being influenced, or indeed whether they knew and approved the content of the will. You know, whether a particular statement indicates that they knew or approved the content of the will. I think at that point they have crossed the line into giving evidence that is outside the scope of their expertise. I think, you know, both of those are paramount questions of fact for the court to determine.
Yeah, I think that's right. And I think one has, as an expert, one has to be very careful. But I would be willing and have been willing to give an opinion on whether X is vulnerable to it. But I've never expressed an opinion as to whether they were subject to it, because it's not my job to do that.
But all that you're doing, Robin, is saying, based on the material that I have seen, this person, and as an upstage psychiatrist, this person would have been vulnerable for the following reasons.
Yeah.
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 Which is entirely within your expertise.
Although some of those red flags are not testator focused per se, but surrounding people focused.
Yeah.
You know, who are the people who the testator depends on for?
Yeah.
That would be outside Robin's expertise. He's not commenting on what the family arrangements are and
Yeah.
who made the appointment to go to the solicitor. That's not his job.
But Aidan, you sort of touched on a point which is the first time I've seen this quite recently, was an expert saying, and therefore I don't think the testator had knowledge and approval of a will, which we jumped on. Do you think there are circumstances where an expert can say there's a question mark over knowledge and approval here? It's sort of irrespective of capacity.
I just don't think that. I think they are two fundamentally different questions. As Paul said earlier, the question is in capacity is, are you able to understand? Not did you understand? Were you able to understand the decision that you had to make at the relevant time? Knowledge and approval is precisely the opposite. It is, did you in fact know what and understand what was in the document when you signed it? And that is, you know, that may be a question of memory. It is a question of language in some cases. There are other factors that feed into it. But I think the two are wholly distinct. Don't, you know, they may well they get pleaded all the time together, but I do think they are different questions.
Robin, have you ever found yourself asked to opine on that and either found a clever way of bringing it in, or just said, no, thanks, I won't answer that?
Yeah, no, I think it's one has to be very, very careful. It's in Hawes v. Burgess, for instance. I mean, I didn't give an opinion on whether she had knowledge and approval of the will, but that's what the judge concluded.
That was what it turned on in the end, wasn't it?
Yes.
So, Paul, what is the most egregious example of expert overreach that you've seen in your career on the bench?
Well, first of all, I see experts in other fields besides this one.
Okay, well, maybe outside this.
But the best, the most naked usurpation of the court's function was in a case about trying to undo a company demerger, and in trying to undo it, it was the person who'd entered into the demerger and had buyer's remorse was not only suing the company and the persons who ran the company, but also suing the solicitors and the accountants and Uncle Tom Cobley and all. And insofar as concerned the solicitors and the accountants, the claim against them was essentially a professional negligence one. There was actually a threshold question, which unfortunately the claimant didn't get over, so it all became obiter. And the threshold question was, were they acting for you or for the company? So it was all irrelevant in a way. But the expert reports were amazing, and I excluded both sides. Because one of the questions he asked was, do you think that the solicitors or accountants, whatever it was, were negligent? And I just said, look, I think I said something like, I'm astonished to find that the question was asked, and almost as astonished to find that it was answered.
It's not the expert's fault that they asked this question, but
So it was slightly less astonishing.
the solicitor should have known.
The solicitor should not have asked that question. But there we are. That's the worst example, I think.
Well, the last question I've got up my pipe is about the scenario where a testator, where a subject is still alive. So this might be a court of protection scenario, or it might be a case where you need to know if a decision this person has made was effective when they made it. Did they have capacity? You know, potentially, are they still in a particular office, or have they ceased to be in that office because they lacked capacity at some point? And the subject is fed up of psychiatrists and doctors and really can't be bothered being prodded and poked and asked to do another Montreal cognitive.
Sign of capacity, I think.
When would you draw an adverse inference from an individual's unwillingness to undergo what in their mind is yet another unwelcome interference from the medical profession? I suppose it could apply post-mortem as well. You might see a testator who said, you've told me I should do the golden rule, I don't want to, so stuff it in, I'm going to make my will. When should an adverse inference be drawn against a testator in that circumstance? And perhaps to open the batting, can I ask Rod or Leila to say, have you had clients like that who say, no thanks?
Definitely had at least one in the last year, and all you can do then is just highlight the disadvantages that lay ahead, not necessarily for them, but for the executors, the family, and that this is a way of lessening the possibility of claims. And it might not be successful, but you're doing your very best to make it as easy as possible for those that are left behind. So that's the sort of angle we took, which I know probably sounds a little bit on the harsh side, but because otherwise you do get people who just, they're tired of it. They're tired of being wheeled around and, as you say, prodded and poked and asked questions on multiple occasions. For some people, it's a matter of dignity, pride, all sorts of things, which mean that they run out of sort of energy to participate. So that's the only thing that I did then. I said, I totally understand it's tiring and it's frankly boring, but it is for the benefit of your family, the executors, and this was a case where siblings didn't get on. And there was sort of an inevitability that there would be, at the very least, sort of handbags at dawn, whether it's actually going to develop into something litigious. There was definitely going to be a row, which was going to be unhelpful. Yeah.
You don't say to the client, the court might draw an adverse inference about your capacity if you don't, just that if you do, it's going to help to avoid a dispute later.
Well, I think it's better to focus on the positives.
That's Paul. What do you think? You think it's a sign of capacity if you don't psychiatric assessment?
I've had one case where a distinguished lady in Oxford declined to see me. I mean, I turned up at the request of her solicitor, and she had agreed. But then And I went in, she said, no, I'm not going to have this done. She went, and the solicitor said, well, if she doesn't want to, I've told her that adverse inferences may be, that may be inferred. But
I mean, they can, it's true, but actually the law on this is I think that there's quite an interesting parallel between the law on DNA testing and on capacity assessment, because in both there are, there is case law to say that the court can order someone to, can obviously direct testing, either a capacity assessment or indeed DNA assessment, and it can go quite a long way in compelling others to facilitate a DNA. Michelle and I had a case in which the P's carer was preventing anyone from accessing in order to undertake the assessment that the court needed to do. And that's something the court has very wide powers to prevent. So, and can issue injunctions and so on. But actually, in both cases, the court does not, and indeed, I think cannot force somebody to undergo either a DNA test or indeed a capacity assessment against their will. It does not cross that final threshold and say, no, you must do this, even though you say you do not want to. In terms of inferences, yes, it can, but actually, well, Baker Tilly is the leading case to say that the inference is never enough on its own. You can draw inferences, and if there are lots of other factors which might support a finding that someone lacks capacity, then that may be enough for the court to conclude capacity is lacking. But what can't happen is for the court to say, well, there's a doubt about capacity, and they won't submit to an assessment, therefore I'm going to conclude. That is an error, because of course the presumption of capacity remains. It needs to be shown by evidence that someone has lost capacity, and I think that's correct.
Paul, can I come to you last on this question?
Yeah, I don't have the COP experience that other people in the room will have, so I tend to deal with dead people. They make less noise. So I'm looking at it from the point of view of the general law rather than specific situations arising in COP. But under the general law, we used to have a number of cases of which the standard Court of Appeal decision trotted out was called Wisniewski, in which the Court of Appeal said that in certain circumstances you could draw an adverse inference against a party who didn't bring forward some evidence that it would have been easy for them to bring forward and so on. And you can see how that applies to people not having examinations and so on. Because as long as it's not too intrusive, it's not painful, it's not difficult, takes 5 minutes, whatever it is, the court might draw an adverse inference. Well, what happened was that was a decision made in about 2002, 4, something like that. And you've got lots of other cases in its wake, sort of building on it and encrusting it with all kinds of interesting variations until you've got this kind of body of rules. So by about 2018, 2019, you could actually write sort of, 3 sides of A4 on what the rules were for when you could and couldn't draw adverse inferences. And so you'd fit your case into that set of rules or not. Anyway, along comes a case called Royal Mail Group and Deathbed in 2021 or 2020, in which the Supreme Court just kicked the whole lot over and said, no, it's all a matter of common sense, don't need lawyers. So the result is that you now look at all the circumstances, and this is general litigation, you now look at all the circumstances and say, is it right, is it fair, is it proper to draw an adverse inference in all the circumstances of this particular case? And you can easily see that if you've got a patient who's been assessed and assessed and assessed and is old and fed up and all the rest, actually it's jolly reasonable to say, no, I'm not doing this anymore. And therefore you don't draw an adverse inference. So I think the point is that in terms of adverse inferences, it's all rather at large. And we're invited, as Judge Bullingdon kept saying to Rumpole of the Bailey, now members of the jury, we'll just go and apply our common sense. So that's where we are, I think, on adverse inferences. But it's worth bearing in mind under the general law, you can actually go further. And I think this comes back to the point about medical evidence and DNA evidence. People who won't consent to something might find that they get sanctioned by the court in the litigation itself. And there's been a jurisdiction for many, many years, decades, of ordering a stay on a claimant in say a personal injury case who refuses to be examined for the purposes of providing evidence at the trial by the defendant's doctor. And that is a clear basis for saying that if somebody refuses to submit to an assessment who has otherwise got a claim, then that claim might be just stayed. If the court considers that it's unreasonable to refuse to consent to it. It's a little more difficult when the person being assessed is the defendant, because you can't stay a defence. But there is at least one case where the High Court struck out the defence, or rather did it conditionally, said, unless by such and such a date you consent to being examined for this purpose, your defence will be struck out. So there are other sanctions that can be applied, which may be even more useful in some cases than adverse inferences. Of course, if the person being assessed isn't a party, then you can't use either of those. But you may have to resort to seeing whether some adverse inference can be drawn. But if they're not a party, then is it really the fault of the parties that person is not consenting?
Thank you. We've pretty much run out of time, but is there anyone who has a burning question for one of our panelists just before we all go for drinkies?
I'm so well. Is there anyone who will hold us back?
Heard you all. Good. Can I just say thank you so much to all of our panelists, to Leila and Rod and to Michelle for answering the occasional difficult question, particularly to Robin and Paul, who've given up their time, and a little bit to Aidan as well.
You, Fiona. Thank you.
It's the 2 pages. Do you know, I don't usually actually sort of for good. Get rid of that. You could, yeah, do that. I want that.
I really
Very, very, very point for us. Yeah.
Tim, yes.
Yes, she has. Yeah. Bring around. Just produce some revised guidance. We can't start inviting you in 3 or 4 things.